story. The reason why you're invited to be on this panel is to provide as an example of the harm that Richard Cordray CFPB pushed upon consumers and individuals and companies. And so let's just talk through structural changes here. So you've dealt with an attorney general, and you've dealt with the Bureau, and you're quite familiar with the law. So did the CFPB ever provide you with any guidance on how to word your disclosures?
Thank you, Ranking Member. We had discussions with the enforcement attorneys at the CFPB throughout the process and actually invited them to provide us the language that they would condone and endorse in writing, and they would not do that for us.
Okay. So have you dealt with other banking regulators?
I have not, Ranking Member.
Have you dealt with other regulators?
Others at our firm, we have a very robust compliance department who I think deal with various other regulators. I personally have not.
Okay. Were there any rules of the road that were given to you from the CFPB?
Before the enforcement attorneys served us with our CID, we'd had no interaction with them directly. So, I mean, beyond that, no.
And in the wording of that document, did it give you reference to law that they were enforcing? A specific law that they were enforcing, or words of a law, or reference to a piece of the criminal code, or?
When the Bureau attorneys presented us with what they considered to be a consent order that they would agree to, it was for the most part their way, take it or leave it.
Okay. So, you've testified to this, but just to be clear, did you just base your disclosures off what had been previously approved by Richard Cordray as Attorney General?
Our law firm has invested millions of dollars over the years in compliance. And again, we have a very robust compliance department headed by one of my partners who heads up our compliance area, who studies the law constantly and stays on top of all the legal requirements. And we based our disclosures and how we craft our letters on the state of the law at all times, which was confirmed when we did work for the state of Ohio and what they would find acceptable as well.
Okay. So in this process, were you ever made fully aware of how you violated CFPB rules?
Well, Congressman, there were no rules that were promulgated in this area by the CFPB.
So as a legal matter, you had no point of reference for whether or not you were, in fact, breaking the law until you were served.
And just to be clear, there is statutory and case law that we follow at all times. I think the Bureau had a different interpretation, which was found by the court, as it turns out, to not be accurate.
So what you're telling me is what was good for Attorney General Cordray was not good for Director Cordray. It's something else. So this scenario has happened many times to many other individuals and companies. What are the structural reforms do you think are needed so that this doesn't happen again, just as a matter of best practices in law, in your view?
Again, Ranking Member, we like to stick to doing our job and doing it to the best of our ability, representing our clients. And as far as structural changes within the Bureau, I certainly defer to Congress on that.
Would a rules-based regime be better than sue and find out later?
As I
don't mean this is a knock on lawyers.
As I stated in my testimony, and I'm certainly aware that there have been discussions of rules in the debt collection area. You know, when we have rules, we certainly intend on following them, and we would welcome the publication of those finally.
Thank you.
The gentlewoman from Texas, Ms. Garcia, is recognized for 5 minutes.